Dear brother Ravana, dear brother Judge of the Supreme Court of India, dear brother Nandraju, Chief Justice of the Bombay High Court, dear brother Bhushan Gavi, Judge of the Bombay High Court, dear sister Bharti Dangre, Justice of the Bombay High Court, members of the bar, judges past and future amongst those who are sitting at the end. Thank you very much for giving me this opportunity of saying a few words. If you find that I've exceeded the a few words, please call the whistle and I'll stop anytime. I have no problem with that. It was very kind of Justice Ramana to say that I should give the keynote speech, although the program said something else. Anyway, the government of India, let me assure you that I'm not going into a section-wise analysis of the Act, that you are all experts on that. You do this kind of visceral analysis day in and day out. I'm just going to talk about the reason why this kind of a legislation was implemented, how it is functioning, and what I see are the deficiencies in this so that it can be improved as time goes on. One note of caution, that all that I'm going to say is my personal opinion, because I happen to be the chairman of an advisory board of the IBC, and it should not be taken as the official version of the IBC at any point of time. The Government of India appointed the Financial Sector Legislative Reforms Commission in 2013 to reform the financial sector of the country, as it was felt that the financial architecture existing in the country was inadequate to cope with the ambitious expectation that by 2030, ours would become a $3 trillion economy, $3 trillion US dollar economy, and that India would be a first-ranked player in the financial world. The FSLRC gave its report in 2013, which is still under process, I would say. One of the significant recommendations made therein was for the establishment of a resolution corporation whose task was to closely monitor the health of a financial firm, give it a helping hand by suitable measures, and finally, if nothing worked, it could be subjected to the winding up process by liquidation. When the recommendation was in itself important, it was made only in respect of financial firms. The winding up process for non-financial entities was still the process contemplated by the Companies Act 1956, and now, of course, the 2013 Act, which would have moved at a painfully meandering pace and could take even decades before completion. That situation was a strong impedance factor for foreign investment in Indian companies. A quick method of resolution of companies was the need of the hour. The IBC was the timely response of the Government of India and Parliament to the grave situation blockading the economic march of the country. The IBC was the result of the recommendations made by an expert committee called the Bankruptcy Reforms Commission, set up by the Government of India, which submitted its report, I think, sometime in 2015. Finally, the IBC provisions initially were made applicable only to companies, but now there is a move to extend it to partnership firms and individuals so that the entire gamut of businesses and non-business entities would be covered by its provisions. The Insolvency and Bankruptcy Code, I'll refer to it as a code henceforth, is considered a landmark reform among the ease of doing business initiatives undertaken by the Government of India. It consolidated all the provisions to institutionalize a common legislation for insolvency resolution and reorganization of corporate entities, partnership firms, and individuals in a time-bound manner. For that purpose, the code provides for a corporate insolvency resolution process that seeks to balance the interests of the stakeholders. IBC is not tasked merely with the autopsy of a company to divide its liquidated residual assets amongst the creditors. Its major task is to revive and refloat a company in financial distress by trimming the fat, reducing fruitless expenditure, and recovering unrecovered debts and dues of the company. The introduction of the IBC has reduced the time taken for winding up of companies in India from over 4 to 20 years in less than a year. The code has also enabled promoters who had driven the company to the ground being replaced from management and new management being installed to drive the company forward. For the purpose of an interim resolution, for that purpose, an interim resolution professional is appointed to take charge of the management. He can now seek resolution scheme from persons who would take into consideration plans for discharging the debts, collecting dues, and running the company to generate sufficient revenues to continue the business for the benefit of all creditors, shareholders, and the public. For this purpose, resolution plans are put before a committee of creditors. If the committee of creditors approves the resolution plan by requisite majority, the resolution plan is then put to the NCLT, which is now the substitute for the company's jurisdiction of the High Court, for approval, and if the NCLT adjudicates any disputes that arises in the process. Significantly, once the resolution process commences, there is a period of moratorium for all claims against the corporate debtor in resolution, and all proceedings are kept in abeyance to enable the resolution process. The process is time-bound and has to be completed within a stipulated period prescribed by law. If the resolution process fails, then there is provision for liquidation of the company, wherein the liquidator is appointed to determine the liquidation value of the assets of the company and distribute pro rata according to the plans of the resolution. Through faster resolution, the code aims to achieve one major objective: to address around rupees 10 trillion of non-performing assets in India's banking system. As the asset quality of banks gets better, it will promote credit and new investments and consequent economic growth. IBC was one of the major factors in India's jump on the World Bank's ease of doing business ranking from 100 in 2017 to 130 in previous year. I may mention here aside that when I was heading the Financial Sector Legislative Commission, I had occasion to deal with a number of foreign business institution associations. And the first question they would ask me is, when is going to be a proper insolvency law in India? They were not bothered about the rest of it. The first question they would ask is, when are you going to have a proper insolvency law of India? And as usual, I had to say, "Achhe din aane wale hain." The code is expected to be a major driver in a spurt of M&A, that is, merger and acquisition deals in India, as bidders are eagerly looking forward to acquire stressed assets, and there are now available at lucrative prices, and a number of entities are coming to the conclusion of the resolution processes. During the first half of 2018, 638 deals worth USD 74.8 billion, including M&A and PE deals, growing by 90% in terms of value and 15% in terms of volume over the previous year. M&A deals alone accounted for a value of 65.45 billion, growing by about 112% over the previous year. Key sectors that could drive deal activity pertaining to stressed assets include steel, infrastructure, and power. Tata Steel's acquisition of Bhushan Steel for 5.5 billion USD was the largest such acquisition at the first half of 2018. The Government of India has set up the Board, Insolvency and Bankruptcy Board of India, as the regulator under the code. This board also regulates three types of insolvency resolution processes through the agencies: interim resolution professional, final resolution professional, and liquidator. The adjudicating authority is, of course, originally the debt recovery tribunal, as in the case of individuals and partnership firms, and other than the limited liability companies. And for companies and LLPs, the adjudicating authority was the National Company Law Tribunal. The process of resolution may be initiated by financial or operational creditors of the corporated debtor itself in the event of a default in terms of a financial debt owed. On acceptance by the adjudicating authority in the case of process initiated by the creditor, and the corporated is given 10 days to appropriately respond and point out whether the debt is due or if there is a legitimate dispute over what is called a debt. And if nothing happens, the whole thing goes into the process of resolution. A major audit, although the one shortcoming was that in situations like in the real estate sector, where a housing contract was entered into between a builder and a person intending to buy the houses, there is no debt as such. It is just a question of a contractual obligation. Now, technically, it would not have fallen within the province of the IBC, and it was the initiative taken by the Supreme Court in saying that this was a glaring lacuna in the system of law that ultimately forced the government to bring in an ordinance and cover them also as operational creditors in the IBC process. This major ordinance was introduced in the case of real estate developers in June 2018, wherein the home buyers were accorded the status of financial creditors, which gives them the representation in the committee of creditors and also allows them to invoke Section 7 of the Code if developers default on their obligations. Another significant amendment pertains to micro, small and medium enterprises for whom the government is empowered to provide a special dispensation. Under the ordinance in June 2018, a promoter of an MSME can bid for his firm under the resolution process, provided he is not a willful defaulter and is not disqualified for any other factors. IBC is a thing whose time has come, to quote Victor Hugo. It is a thing that is going to accelerate Indian economy to greater heights by promoting entrepreneurship and ensuring effective use of capital. Insolvency law is certainly the game changer, but non-adherence to timelines and inordinate delays in admission of cases are some of the major concerns, especially where a debt is well established and one does not have to determine the quantum of debt, rather than one having to determine whether there is a default, which might defeat the objective of the code itself. People are gung-ho about IBC. People have been praising the IBC, but there is always a flip side of what is happening. It is necessary for us in debates like this to ensure that if there is a deficiency, to highlight it so that the powers that be can take notice and resolve this issue of the deficiency that has come to light. Now, what are the problems with IBC as it stands today? The shortcomings can be divided into three parts. One, structural reform. Two, what does the law say and intend? Three, what are the problems? Why is ABC a seminal structural reform, as everybody has been saying? It is because for long our solutions towards strengthening the creditors' rights were piecemeal, ad hoc and knee-jerk. We enacted SICA, that is the Sikh Industrial Companies Special Provisions Act, under which a board of retired bureaucrats decided whether a Sikh company could be rehabilitated or should be liquidated. We set up debt recovery tribunals, which are meant to benefit only banks and large lenders. The idea was to circumvent the ordinary civil judiciary, which is largely perceived as losing its efficiency because of long delays. We enacted SURFACE, allowing secured creditors to take possession of the security without going to court. Again, a measure to shorten the time taken by courts in enforcement of securities. The banking regulator, that is the Reserve Bank, enacted a series of schemes such as the Corporate Debt Restructuring Scheme, CDR, the SDR, and so on and so forth. What was the problem with these schemes? First, only banks could access them. Second, the lack of transparency to all the stakeholders on the manner in which the resolution was agreed to between the large creditors and the debtor firms. IBC is a structural reform because it changes the way we in India think about bankruptcy. It looks at a limited liability company as a contract between equity and debt. As long as debt obligations are met, equity owners have complete control and creditors have no say in running the business. When default takes place, control is transferred to the creditors, equity owners having no say. What are the key principles? IBC serves three purposes. One, it provides a forum for collective action by all creditors without giving preference to any one type of creditor. It provides for limited claim period where nobody will litigate to recover, and results and entrusts commercial decision making to creditors who are the largest stakeholders in the process. What are the three principles on which the whole thing starts? One key principle is that the promoter or the existing management is dispossessed of management and the debtor is placed in the hands of a resolution professional who runs it as a going concern under the supervision of the creditors. The threat of loss of management instills a certain credit discipline. Today, insolvency can be triggered by any creditor, irrespective of his size. It can be triggered by vendors and employees who, under the legal regime, had little leverage over the credit debtor. Second, it leaves the commercial decision-making to all the creditors, not to an external board, nor to a court of law. As soon as the resolution professional is appointed, the creditors committee is constituted. The creditors committee comprises financial creditors, banks, bondholders, etc. The resolution professional runs the debtor as a going concern under the supervision of the creditors committee, invites bids for the firm, and all important decisions are taken with the 66% vote of the creditors committee, which I believe will act by taking into consideration business and commercial considerations. This is a paradigm shift where we rely on the creditors to act in their own best interest. Third, the process for resolution is time-bound. If no resolution is agreed upon within 180 days or 270 days with the approval of the court, the debtor goes into liquidation. This incentivizes everyone to negotiate rationally, as in liquidation, stakeholders will lose much more. What are the real problems with the IBC as it exists today? Key problems that have crept up and threatened to cripple the structural changes are: one, an explicit bias against liquidation. We in India have this kind of a bias in the judicial system. We always say in a divorce matter, we should try to save the marriage. This has influenced the thinking in the IBC also. In a modern market economy, liquidation of unsustainable firms must happen so that resources can be reallocated to more productive activity in the economy. The process of creative destruction should be acceptable to a society for progress. What we are seeing playing out, however, is an explicit bias against liquidation within the government and in the courts as well. The bias against liquidation is not in the letter of the law. The Supreme Court in the ArcelorMittal and Swiss Ribbons case read into the preamble of the law and the regulations to interpret the law as being biased towards resolution and rescue. A bare reading of the process laid out in the law bill, however, indicate that the law is outcome agnostic. It merely prescribes a process which must be followed before liquidating a firm. What are the costs of such a bias? First, the bias manifests itself in extended timelines for resolution. Research by the Finance Research Group shows that the probability of a case being resolved within the first 180 days is less than 5% in a bankruptcy case. The estate of the debtor is like a melting ice cube. As more time passes, the creditors lose value. Second, the bias manifests itself through increasing judicial intervention in commercial decision-making, which defeats the original purpose of the law itself. Third, an extended timeline for resolution implies that the moratorium is also extended, which creates scope for abuse. There are explicit judgments which endorse repeated rounds of negotiations as well as judicial intervention to rescue a debtor who, under the strict letter of the law, ought to have been liquidated. For example, recently a string of jurisprudence has emerged from the NCLAT on the efforts to be made for selling the firm as a going concern even in a liquidation phase. Basic knowledge of accountancy will indicate that no firm remains a going concern in the liquidation phase. Auditors themselves will refuse to sign a statement that a firm is a going concern in the liquidation phase. While the intent underlying the bias may be very noble and may bring benefit in the short term, but in the long term, rescue jobs and terms, there are huge costs of such a bias for the entire system. It brings unpredictability in the insolvency process and skews incentives in favor of delays. Overall, the borrowers suffer as this drives up the cost of credit for the entire system. It also creates uncertainty in the law. Amendments have been a regular feature of the new IBC regime. With the IBC itself having been amended twice, amendments to the Banking Regulation Act had a direct bearing on the IBC itself. It is true that this may be taken as an indication of the responsiveness or alertness of the policymakers toward the problems faced in the implementation of the law. However, reacting to every problem with a legislative amendment is not only unnecessary, but also increases the overall uncertainty in the implementation of this new law. As a matter of fact, some of these amendments have given rise to their own set of problems. Two examples. The amendment which brought Section 29A intended to keep willful defaulters from participating in resolution of firms. In an effort to exclude willful defaulters, the language of the amendment has cast too wide a net. It became the source of long litigation in several of the large insolvency cases and increased the overall capacity required for a tribunal to bring cases to a timely conclusion. The amendment to the Ranking Regulation Act, which added Section 35AA and 35AB, which empowers the central government to direct the RBI to turn direct banks to trigger the IBC for defaulted loans. The constitutional validity of the provision was challenged in the Supreme Court. The provisions were added to address a concern that could have been easily resolved otherwise, namely, how do we compel banks to use the IBC in a timely manner for resolution of the NPS? While the constitutionality of the provision was upheld, the Supreme Court struck down the circular issued by the RBI in exercise of its powers confirmed on it under the procedures on the ground that the RBI cannot direct banks to trigger default on a principal basis, but it must wait the instructions of the central government to trigger the IBC for specific defaults. That throws the ball into the court of bureaucrats again. The judgment of the Supreme Court in the case Dharani Sugars implicitly supports the notion that the central government will exercise discretion in selecting cases which must go into insolvency. This is problematic at many levels. It affects the independence of the central banks as the banking regulator and vests tremendous discretion in the central government. The alternative to this approach of the central government or the RBI identifying which defaults must be taken to IBC is to revise banking regulation such that banks are incentivized to trigger the IBC in a timely manner. In other words, invoking the IBC must left to the commercial decision of the creditors. This must be supported with an appropriate prudential regulatory framework that incentivizes largely recognition of default and appropriated provisioning once a firm has defaulted. The key takeaway in all these ad hoc changes to the law increases the uncertainty on two counts. One, due to the legislative amendment itself, and second, due to the interpretation of the law, the new legislative amendments. Finally, there is this capacity issue. People often bemoan the capacity issues of the NCLT and the NCLAT. Enough and more has been written about the poor infrastructure at these tribunals. While the government is working to set up new benches to deal with the workload, the truth is that merely increasing the quantitative bench strength will not solve the problem. Given that tribunals are now a recent reality in India, we need to think about tribunals much more systematically. The Supreme Court in the case of Swiss ribbons specifically directed the central government to ensure that tribunals are kept independent of the Ministry of the Government. That is in charge of implementing the law. It directed that the administrative support to tribunals must be provided by the Ministry of Law and Justice. While this is done in order to ensure the independence of the tribunal, the critical question is whether the Ministry of Law and Justice has the capacity to handle the work of systematically planning and supporting tribunals. Serious thought on this issue was bestowed in the report of the FSLRC, which had recommended setting up a separate administrative body that would be dedicated to the task of systematically planning and administratively supporting tribunals. This idea is not new. It exists in the developed world for courts. It was recommended by the Supreme Court in the 1990s in the case of L. Chandra versus Union of India. It is about time that the government takes this issue seriously. In the absence of systematic planning and a dedicated administrative support body, no amount of legal reform will ever produce the required results. Similarly, the critical institution of information utilities, which is envisaged in the IBC, has not yet established itself in a credible manner. The information asymmetry with this institution was expected to dissolve, therefore still persists. The most stark capacity gap is in the creditors' committees. For the longest time after the IBC was enacted, representatives of banks attending the meetings of creditors' committees did not even have the authority to vote, or that decisions were overturned. This has been partly addressed by the IBBI now. Finally, the philosophy behind all this bankruptcy. One big problem today is that decision making at the level of banks continues to be hindered under the shadow of the three C's, the CAG, the CVC and the CBI. Credit decisions which are purely commercial may or may not turn out to be correct. However, subjecting every credit decision to scrutiny by investigating agencies is certainly problematic. It freezes risk-taking, inducing cold feet in the force that drives commerce. The fear of scrutiny by investigating agencies similarly hinders decision-making during the process of insolvency itself. A credit decision is a commercial choice. If it goes wrong, the business judgment rule applies. At the most, shareholders and others affected creditors must have access to the efficacious civil remedy against the decision maker. To criminalize either default or other commercial decision can freeze business and overall growth. One hopes that these points are kept in mind by the powers that be, and whatever new amendments that are required in the matters of policy implementation, in the matters of implementation and betterment of the law is done with a view to ensure that the business really takes off, and then we are able to achieve our ambitious target that by 2025-30 we will be a $3 trillion economy. Thank you.